new digital clock that sits before my face on the wall. Even my old eyes can now read the time. They didn't
We're supposed to be collecting admissions tickets to pay for the clock.
pay for the clock. We're going to fix an alarm up to that from now on so we can limit argument time like they do in appellate court. But good luck with that. Well, welcome to the December 2014 Zoning Hearing Board. And we've got 3 cases on the docket tonight. Unless anybody has any business to address of a general nature or wishes to request a continuance, we'll go right into the first case, which I will read from the legal notice. Appeal number 2929. The applicant, Scott Keeley, property located at 210 Landover Road and zoned R5, requests a hearing regarding an enforcement notice of Radnor Township dated September 23, 2014. Applicant seeks a special exception under Section 280, 115.2 for a student home, seeks a variance to Section 280-115.2 sub E to allow the student home to be closer than 1,000 feet to another student home and/or such other relief as required. Is the applicant present?
Yes.
And I want to point out to the members of the board, if you have a bound copy of the ordinance as I have, this was an added section which should be in the back in an envelope that's in the binding right before the rear cover. But it's also set forth in full as an exhibit to the application if you can't find it in your...
I didn't have it, but I...
It's back
On the
here.
internet.
Okay. Because this is the kind of case where it's going to be of great concern to know all those particulars. Okay, you Mr. Keeley?
I am. Yes. I'm Peter. What's that?
Welcome, Peter.
Oh, okay. I thought you said yes.
You're appearing for the township.
Yes, I'm appearing for the township. My name is Peter Nelson. The township is appearing
Peter.
to defend its enforcement notice and also in opposition to the request for the special exception and the requested variances. Since this involves an enforcement notice, and since the last time I was before you on this issue, I believe I need to go first and have the township meet its burden of proof on the enforcement notice.
Fine with me. Go ahead. We're going to hear both sides, so
Yes.
I care not who goes first.
Okay. So, am I free to move forward?
Mr. Chairman. Mr. Chairman, is he free to move forward?
Where else would you go?
I just want to make sure you're all set. That's
I'm
all.
all set.
Thank you. As my first witness, I'd actually like to call Mr. Keeley as a cross.
I think you did that last time we went through.
That is correct.
Okay.
Then you'll raise your right hand, I'll swear you in.
Talking to me?
Mr. Keeley? Yes. You do solemnly swear or affirm this testimony you're about to give will be the truth, the whole truth, nothing but the truth.
Yes.
Thank you. And state your full name, spell your last.
Scott John Keeley, Keeley.
Mr. Chairman, before we start, we have a lot of exhibits. We have a lot of exhibits that were sort of all bundled together. It might be worth entering them, and so that everybody is following the text.
Perfectly fine with me.
Not all right, gentlemen?
Well, these exhibits were all submitted by the applicant, so.
Yeah. I was going to say the first exhibit
Yeah, I
will
got
be
copies. Yeah.
the application.
Peter
We'll
Nelson.
make that A1.
Okay. Hold on.
The second is a plot plan of the
Pardon?
premises.
Well, I think we can skip these requirements of our board. They're
Well, since it
attached,
was an
but
enforcement notice, normally
they're really
it's
not
automatically come.
relevant beyond
Okay.
our normal procedures. They were attached.
I'm sorry, we were speaking. Could I ask what were you marked as Exhibit B1?
A1.
Or
was
A1?
Just the application form.
Okay, thank you.
I mean, the other thing is we could just put the whole application in without subdividing the various exhibits. We ought to decide how you.
I just think the only problem with that is then we're not going to be able to refer to things specifically.
Okay, how about
So-
the Plan B A2? I'm taking ones they came off on my printer.
Not the enforcement notice?
No, I think I got the plan, just how I printed them out. We can do the enforcement notice first. Let's do that. A2,
Let's see.
okay. Do we need to include the zoning requirements? I mean, they're of, you know,
No, they're a public record.
they're a public
Very
record.
public.
they're
I will be referring to them in some of my examination, just to forewarn you, but
Why don't we just put them in? I know they're a public record, but if people want to refer to the thing. Sure.
All right.
So that, the guideline, the requirements will be A3.
Well, why do we need that? No one's going to refer to that for the
He said-
purpose of...
the
Nelson just said that he might.
the guidelines, are you talking about the guidelines, or are you talking
No.
about the exhibit?
No, he's talking about the rules of our board.
Oh,
that
no,
were
I'm not,
attached.
no, I'm not referring to
You're
those.
probably referring to the zoning section that has all those...
Exactly,
Yeah,
yes.
we're
Okay,
gonna-
then we don't need the requirements. And I point out, they're no longer guidelines, they are requirements. Okay, I have the zoning code, section 115, 280-115.2, which I would recommend we make A3. I've got the special warranty deed, which I would recommend we make A4. There is an agreement of sale with an addendum, which I would recommend we do A5. Okay, there's a plot plan, which I would recommend we label A6. There is a document called a residential lease between Mr. Keeley and Tomas de Abreu and Connor Doyle. I would make that A7, and I hope I pronounced those correctly. And there is another similar lease between Mr. Keeley and Jason Stankiewicz and Zachary Rabley? Does that make? Rabley, I'm sorry. Make that A8. And there is a package of photographs, which I would make A9.
Is that a set of 4 photographs?
Yes.
Okay.
And since we're not including our requirements, I believe that exhausts what we've received to date.
Now, before you proceed, Peter, why don't we give you one of these to put up there? That way you won't have to share the same mic for question and answer. It's off now, but just turn it on if you need it.
I'll give you this, and then I'll speak into this. So. Mr. Ryan, we all set to proceed?
Mr. Chairman?
Fire away.
Okay, great. Mr. Keeley, are you the owner of the property located at 210 Landover Road?
Yes.
If you have to keep your voice
Yeah.
up, make sure
Yes.
that mic's on.
And as the owner, did you lease this property to 4 students this school year?
Yes.
And I'm going to show you a document that's been previously marked as Exhibit A7. As I introduce these, I have copies for the board. Do you need my copies, or do you already have all of them?
Yeah, we have A7.
Okay, so all the ones that have been pre-marked, I don't need to show you.
You do not.
I'll hand it to you. Do you recognize this lease, Mr. Keeley?
Yes.
And this is a lease that you entered into with 2 students for the house at 210 Landover Road?
Yes.
And these students are currently living in that house?
Yes.
I'm also going to,
It's my copy.
yeah, you can keep that. I'm also going to hand you a copy of exhibit that has been, or a document that has been previously marked as Exhibit A8. Can you identify what that is, sir?
Residential lease.
And that's the lease between Mr. Stan Kowitsk and Rabley and yourself?
Yes.
And this is a lease for the property at 210 Landover Road?
Yes.
And this is a lease that you entered into with students for this current school year?
Yes.
And these students are currently living at the property?
Yes. It's actually not the school year, it's fiscal year.
Right.
Full year.
Correct.
Yeah.
And it runs from June 30, or July 1st to June 30th?
Not July 1st, no. The lease begins June 1st
Okay.
to May 31st.
Okay. And that's for both of those leases, A7 and A8?
Yes. Yes.
And all four of these students are currently living in the house at 210 Landover Road as we speak?
Yes.
Now, the township became aware of the students living at this house and issued an enforcement notice against you, is that correct?
Yes.
And I'm going to hand to you a document that's been previously marked as Exhibit A2. Is this a true and correct copy of the enforcement notice that was handed to you or delivered to you in regards to these student tenants?
Yes. Yeah, I received it in the mail.
And when you received it in the mail, you filed an appeal to this enforcement notice with the Radnor Township Zoning Hearing Board, is that correct?
Yes.
I'm going to hand you a document that's been previously marked as Exhibit A1. Is that a true and correct copy of the appeal you filed?
Yes.
And before you leased the property at 210 Landover to the four students, you did not receive or apply for or receive a special exception from the township, did you?
No.
Before you leased the property, you did not receive a student rental license from the township, did you?
What would be the difference? Well,
You
did not,
You
but what is
didn't
the
apply.
difference?
You didn't apply. There's a license annual license you need to apply for student rental housing. Did you apply for such a license? Okay. And obviously, you did not receive such a license.
No.
That is all for this witness. Thank you. I do reserve the right to cross-examine him after he's presented his direct case regarding his variances.
Mr. Keeley, what's the square footage of the building?
Um,
Excluding the basement?
1,900 square feet?
And it's a duplex, correct?
Yeah, it's the left side of a duplex.
Left side of a duplex.
Well, is it a duplex or is it just a
Well, I don't know the
a
correct...
twin home?
It's a twin.
In other words, you own one half,
I own
someone
the
else
left
owns the
side,
other
And
half.
there's a separate homeowner on the right side.
Yeah, that's not a duplex. It's
No,
a,
that's-
it's,
that is-
well, we used to call a semi-detached
I've
house, they
heard-
call it a twin house
yeah.
now.
It's a single-family home.
Yes.
Yeah, actually,
half double.
I wanted to go down this list of things from the ordinance and just get some facts from you before you start. You're well aware of Section 281.15.2. That's what's at issue here, and in fact, you attached a copy to your application. So let's just go down and look at A. So the first one is that it's a single-family dwelling, so the answer is yes, it is.
Yes.
Okay, now B, it said shall not be permitted within a two-family dwelling unit. So obviously, it's not, right? That's
No.
your testimony.
Correct.
Okay. C, more than one building on a lot may be used as a student home. Is it the only building on the lot, absent garages and things?
Yes.
Okay. D, D really is not relevant. That's where the exception expires, but no one was granted here. E, no student home shall be closer than 1,000 feet to another student home property line. The distance requirement is measured from the closest property line of a potential student home to another student home property line. I take it from your application that this is within 1,000 feet of another student home. Is that correct?
After communicating with Radnor Township, I was told it was.
Do you have an idea of how close just for the information on the board?
The nearest student
Yeah.
rental, or it's not, student housing, I mean?
Well,
It's
the
not-
nearest student home, not a dormitory, but I mean, someone else who's doing what you do. Basically, about how far would you say it was?
From the property line or from the housing?
Property line to property line. I mean, I'm not looking for
Yeah,
exact feet.
10 feet,
but-
I don't know, I mean, well, there's a driveway in between me and the next house.
Oh, so it's the next house that's a student home?
Yes.
Okay, I was wondering,
Different
could have
street.
been something on the next block.
No, different
Okay.
street,
Okay,
but
distance.
I'm on the corner.
So distance is an issue.
Excuse me, Mr. Chair.
Yeah.
I just want to make sure I understand this. You're saying, and maybe the solicitor can clarify, you're saying that within a very short distance, there is another licensed student home?
According to what I was told from Radnor Township. I didn't-
Actually, whether it's licensed or not isn't relevant under the code.
If
Wait,
that-
yeah, I don't know if it's licensed. I know there's students living there.
Mr. Chairman, if that's the case, it's not really necessary to go through the special exception list because by definition, he's not complying.
Oh, yeah, I think there's really two issues in this case. The first issue is, do we reverse the decision of the township officer in citing him? That's one issue. Second issue is, do we grant relief, which may prevent continuing violations from occurring going forward? He's asked for both special exception and variance relief, as well as appealing from the decision of the zoning officer.
But my understanding is he's acknowledging that one of the requirements for a special exception does not exist. So any.
But we
further-
could give him a variance.
Right, so why don't we just talk about the variance? To continue to talk about special exception makes no sense.
Well, actually, I think technically we'd have to grant him the special exception and say we're giving him a variance to violate one of the sections that he would otherwise have to comply with in order to get it, because of the way it's worded. I think that's what we'd have to.
Thank you for the clarification.
Okay, next, the rules and regulations applicable to the conduct of student tenants and student housing authorized under the section shall at a minimum conform to those applicable to on-campus dormitories of the college, university, wherein the student tenants at issue attend. The owner shall provide proof of such rules and regulations to the township. So what colleges and universities do these occupants attend? You know?
Villanova.
They're all Villanova
All
students?
Villanova.
Do you know what the regulations are for the dormitories at Villanova?
I do not.
Okay, so even if we were inclined to work with you, you could not bear that burden of proof under F. So F is an issue. Okay. The student home shall have a minimum of 1,500 square feet of living area, exclusive of the building area covered by a basement, garage, or an accessory building. Now, when you consider those factors, you still say it's over 1,500 or not?
Yes.
Okay. The student home shall meet the minimum yard setbacks, lot area, and lot width requirements for a single-family detached dwelling within the zoning districts. Do you meet all the,
I don't know. I don't know what those are, but that's the reason I got the land.
I mean, it's your burden to come,
Yeah.
show those facts and show that you meet that
Right.
requirement, or you're not going to get a special exception. So you're not prepared to meet that burden?
I'm not.
Okay. We're not in business to continue with this now. Let's see, H. That was H. Let's see. Yeah. I, noise abatement measures acceptable to the town. Well, we don't know about conflicts with the neighbors, so we can't really get into that. J, is there a buffer area with a width of 10 feet around all student homes, rear and side lot lines? Well, that can't be because the plan you showed shows that this is an attached home. So you couldn't possibly have a buffer area of 10 feet in width around the rear and side property lines because you have a party wall at one of the property lines.
Right.
Okay, so J is an issue. Okay, we don't get into that landscaping required. We don't know what that is. That's how you'd find all that if you went in for an application to do this. They would come out and inspect the property and deal with all this stuff. L, the number of persons living in such student home shall not exceed 2. Any number of persons in excess of 2 would tend to create, well, that's just the explanation. You've already testified, I believe, that there are 4 people living here.
Yes.
Under leases. So that's L.
In your property that you own, I understand it's a twin, but on your side of the twin that you own, is that separated in some fashion, or all 4 tenants living together? Is there any like subdivision between the front of
No.
the building and back of the building?
Different floors. There's,
But it's not divided into separate flats, living units, apartments?
No.
Otherwise, you wouldn't have been able to answer that it was a single-family home?
yeah.
It is a
All right,
single-family
that's what we
home.
got.
Yeah.
Got it. Yep.
Okay. Student home shall meet the minimum area, yard setback, lot width, and other area and bulk requirements for single-family detached dwellings unless otherwise specified herein. So that basically says you really can't have a student home unless you get a variance that has a party wall, because it has to meet the requirements for single-family detached dwellings. So that kind of modifies the one about the 10 feet around.
Okay.
So M is an issue. And you have a minimum of 2 paved off-street parking spaces to the side or rear of the premises and not in the front yard, in addition to those otherwise required for a single-family home. How many parking spaces do you have?
2.
Only 2, and they're not in, are they in any of the yards? I think they're in a front yard. You're a corner lot, you have 2 front
the back.
yards by code.
Well, it's in the backyard. If you, considering the front of the house is on Landover Road.
Now, under our code, if you're a corner lot, you're deemed to have 2 front yards, 1 on each street.
Okay.
So even if you had 2, that wouldn't be enough anyway. You have 4 people living there, plus the normal requirement for a single-family house. Okay, so parking is an issue.
Excuse me, Mr. Chairman. Among the photos that were identified as an exhibit, there's one photo that includes a bike and sort of an area there. Is that the parking?
No.
Okay, thank you.
I'm sorry, what was your answer?
No.
I think the plot plan, I don't have it right in front of me, shows where the parking is, but it's partly in the front yard along the other street, not Landover Road, but the other street. The next requirement is that you would have procured from the township the annual license, which you've already said you have not done. And the owner of the property shall provide the township with the number of students that reside within a student home and shall provide the name and contact information for each student residing therein. Of course, that wasn't done. It's in your application now, but you
It is
never,
now, yeah.
never did that. Okay. The owner of the property shall notify the township when there is a change in the individual student residing. Well, the township's been notified of nothing, right? So that hasn't been complied with. Or, no student residing within the student home shall conduct himself or herself in a disruptive manner. We can't really speak to that tonight. No other, is there any purpose for this, what's going on here other than residential purposes?
No.
I can't ask you to answer T as to yourself, because that would require you to possibly incriminate yourself, but that goes with illegal conduct on the premises. Exterior appearance will be maintained so as to resemble dwellings immediately, well, we'd have to do an inspection. That's one of the reasons why you apply for a license, so they can do that. Okay. It's important to notice V, the section is not intended, nor shall its effect be, to limit any other enforcement remedies which may be available to the township against an owner, student, tenant, and/or guest thereof found in this chapter and/or other applicable law. So we really, before you present whatever you want to present to us, we have to be conscious of the fact that there are 2 issues. First of all, you've been cited for a violation, which could include a hefty fine with it. And then the issue is going forward, are you going to cure this, or are you going to be accruing these fines until you cease the unlawful conduct? So there's really 2 different issues here. Granting you a special exception and whatever variances may be required in order to get you within the special exception parameters, should we decide to do that, is not necessarily going to cure your past violations, because you have violated them and you've admitted violating. So it's 2 different issues. So keep that in mind when you're presenting what you want to present to us. I think we've probably covered a big part of your case just by asking you these questions, but
Yeah.
the floor is now yours if you want to.
Is it possible for me to just ask a follow-up question to your line of questioning at this point in time?
Well, let him put on his case. You've yielded the floor to him. You've reserved a chance to rebut. So,
Okay.
Peter, why don't you wait and let him
That's fine.
tell us whatever else he wants to
to
tell us.
Mr.
John?
Chairman, based on the testimony we have just heard, I think this, not only is it clearly not a special exception case, but I would submit it's a use variance case, not a dimensional variance case, which means that there's a stronger quantum of hardship. The standards for granting use variances are much tougher than the already tough standards for a dimensional variance.
Let me float something, John. This is for all members of the board to consider, and I'm addressing this to our solicitor. That is, I think we already cannot grant the variance or the special exception based upon his answers to the questions that I asked based upon the provisions of the ordinance. I think he's already taken himself out of that possibility because the property physically will not qualify regardless of whatever else happens. Doesn't qualify under the ordinance. So, given that fact, I think we can entertain a motion and vote on that issue. And the question is, then we have to vote on the appeal, whether or not to overturn
think
the violation.
He's asked for any other relief, which I think is broad enough to include a variance, but he'd need variances from these provisions, and they'd be use variances.
In order to get the special exception, because the way it's worded, it says you have to have the special exception.
I don't, well, it says that, but it also says you don't qualify. I think it's a variance case. I think I don't think that the special exception mechanism is available here. So you could condition the any variance relief you wished to give if the board wishes to give it. And if the board feels that the applicant has met its very stringent burden of hardship. And unfortunately, the burden goes with you in a variance case. It doesn't go with the township or the objectors. And we were clearly in violation of the ordinance, and we're clearly in violation of several predicate requirements for a special exception, which shifts the burden to you in getting a variance. And you've got to show us that this property is impossible to use, is zoned, has no reasonable use. It's a very tough standard. If you clear that, you've got to convince the board that it's the minimum relief needed to alleviate the hardship. And the ordinance speaks to that by saying no more than 2 students in a student home. So I think there's a presumption there of reasonableness, and then you have to show, and again, your burden, not anybody else's, that this use will not be detrimental to the community. So those are the hoops, and they're tough hoops to clear. This doesn't speak to fines or what the township does as to the violations up till now. But if the board decides to give you variance relief, and I'll have to say, I haven't seen the hardship or the variance conditions yet that would make that something the board would do. And you have to keep in mind that variances are not supposed to be granted, and unless the hardship and other requirements are met. And if we do grant such a variance that is not supportable on a very tough record, we would be reversed by the Court of Common Pleas on appeal.
Now that he knows what his task is, can we allow him an opportunity to speak?
One more thing, you have to realize the hardship must not be self-created. So to the extent that you created your own hardship, we cannot and will not give you relief. And seeing your name on these leases with 4 people kind of slams the door in my mind, but question is how much
Chairman,
time do we
let's-
want to take on a case that can't
Let's
go
let the
anywhere?
applicant put
Okay.
forward
All right.
what he chooses to present.
Yeah. We went over a lot of the,
Please use one of the microphones.
we covered a lot of the arguments, and obviously there's some things that are out of my control because of the way the property's set up, but I just wrote a few things down that whether it's an argument that changes your mind or not is I'll read it. It just says, I'm appealing the enforcement notice that I received back in September 23rd. After I received the enforcement notice, I did a lot of research and spoke to the renters in my home, letting them know that 'cause at first I wasn't going to appeal a decision. I let them know that they had 30 days to move out, as what the ordinance stated. And they, after speaking to them and speaking to a lot of other people, I realized that it's a very tough situation for students from Villanova to find quality housing in Radnor Township because of the limit that Radnor has put on the approved student housing, which is, I understand why it was put in. And a lot of the students that we found that live in approved housing, the housing is of substandard. I went into a couple of houses that are approved student housing, and they're in poor condition. They have holes in the walls. Subfloor is exposed, lack of paint. A lot of the appliances don't work. That's what my argument is the house I live in, or the house that we're speaking of today, I did a lot of improvements to it. The roof is brand new. All the appliances work. Everything's painted. There's no stains, no holes in walls, things like that. So basically, is the reason I'm here is for that argument. Whether it's a good one or not is your decision. And basically, that is it. I offer the off-street parking. I thought was, since it's a corner lot, I wasn't aware of that. Not ordinance, but the rule that you said a corner lot has 2 front yards, so I wasn't aware of that. So in my argument, I did say it has 2 parking spots for cars. So other than that, so that was my argument for the appeal.
You talked about where you live. Do you live in this house?
No,
Okay,
I'm speaking of the house,
okay.
the
Well,
210 Landover Road.
Mr. Keeley, you indicate you fixed the house up. Would the house be appropriate for a single-family home to live in, or a single family
Yeah.
to live in it?
Yes.
Thank you.
Okay, do we have anyone in the audience that has standing who would like to be heard on the issue? What you're,
I still have one other witness.
oh, I'm sorry, okay. Go ahead, Peter.
I'd like to call William Miller. Mr. Keeley, you don't mind if you can stand here?
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, nothing but the truth?
If you can just have that
And state your full
microphone.
name for the record, please. Thank you.
Bill, why don't you take one of these also? That way everybody will have a mic,
Okay, you want?
because the applicant may wish to cross-examine you after you're done. He'll need a mic.
Mr. Miller, can you briefly, for the record, just explain your employment background and what you do for Radnor Township?
Okay, I am presently a code official with Radnor Township, the interim zoning officer, having been appointed since our director, Kevin Kochanski, was activated into the military. I've been with Radnor Township approximately 15 years. Prior to that, I worked for Westchester Borough as a code enforcement officer for 10 years. I carry 14 certifications with the state of Pennsylvania as required by the Uniform Construction Code.
And in your capacity as the zoning officer, did you be made aware of the issues discussed at 210 Landover Road?
Yes, I did.
And how were you made aware of this issue at this property?
We received an anonymous complaint through our computer system here that went to our police department when it was forwarded to us.
And just to provide a little information regarding the location, I'd like to hand you a document that I would like to have marked as Exhibit T1. And Mr. Miller, while I'm handing these up to the board, could you just describe the location that the property is located in?
The property is located in the Bryn Mawr area of Radnor Township. It's a corner property, which the front of the dwelling faces Landover Road. The side of the dwelling faces Brook Street.
Thank you. On the exhibit I handed to you, marked as Exhibit T1, there's a little red spot, correct?
That's correct.
Is that the location of this property?
Yes, it is.
Okay. And you heard Mr. Keeley testify earlier regarding another student rental house being located nearby. Do you know where that house is?
That would be 709, 711 Brook Street. It's two properties that are adjacent to the rear of that property right next to it.
Okay. And did you have the chance to examine whether or not there are any more student rental housing properties located within 1,000 feet of this property?
Yes, we have a map info program, and on that particular program, we have the student rentals identified by red dots on the program, and we have the ability to draw a 1,000-foot radius, which I did on this property today, and I identified 15 properties that are student rentals with a total of 19 units that are within that 1,000-foot radius of 210 Landover.
And
No, when there are two houses within 1,000 feet, which one wins? The first one with the license?
I'm sorry, I'm not sure what you're asking, Mr. Nagel.
Well, there's two properties within 1,000 feet. One of them's in violation, right?
Well, if they're existing houses, then they're legal non-conforming. If it's a new one, then it would be whichever one applies.
Whoever gets their license first.
Whoever gets their license first, yeah.
Yeah, this section took place, it just got added on the,
A couple of years ago.
in 2011.
Yeah.
Yeah, we have several properties that are non-conforming, these 15 properties being amongst those.
I see. Okay.
and Ms.
They do not conform to the 1,000-foot radius. They existed prior to...
Please use your microphone, because people are listening at home, and our reporter has to hear it. And
Because they were student housing before the ordinance was in
They were
effect.
prior to the existence of this ordinance, so that the new ordinance makes them non-conforming to the ordinance. They do not conform to the 1,000-foot radius of the present ordinance.
Okay.
So
And-
they are legal non-conforming.
Mr. Miller, I just handed you a document that's been marked as Exhibit T2. Does that document list all the properties you've been discussing regarding being within the 1,000-foot radius of 210 Landover?
Yes, it does.
I'm sorry, I'm skipping ahead trying to save some time here. Just give me a second. When you were made aware or received a complaint regarding a possible student home at this location, what steps, if any, did you take?
We notified Mr. Keeley verbally by telephone, and we also I sent him the enforcement notice.
And I'm going to hand you a copy of the enforcement notice that was previously marked as Exhibit B2. Is that correct? Or not B, A2?
A2, yeah.
Okay. Is this the enforcement notice
Yes, it is.
you sent Mr. Keeley?
Yes,
Okay.
that's correct.
Thank you. And what actions, if any, did Mr. Keeley take after you served him with the enforcement notice?
We spoke on the phone several times, and then he eventually filed the zoning appeal with the township.
And that zoning appeal, that's what the document that has been previously marked as Exhibit A1.
That's correct.
Here we go. In regards to becoming a student home, what does Mr. Keeley need to receive?
He needs to receive a license, a special exception from the zoning hearing board, and then eventually a rental license from us as a student home.
And in order to receive this special exception, does he need to comply with the provisions set forth in provision 280-115.2 student home?
Yes, that's correct.
And those provisions are set forth in the zoning ordinance?
Yes.
And you attached them to your enforcement notice?
Yes.
And they've been previously marked as Exhibit A3?
Yes.
In going through some of these requirements, looking at provision E, no student home shall be closer than 1,000 feet. Obviously, this home does not comply with that requirement.
That's correct.
Have you ever received any rules or regulations from Mr. Keeley regarding the conduct of his tenants?
No, we have not.
Have you had a chance to look at the dimensions of this property to see whether or not they meet the dimensional requirements for such a house, a detached single-family home in the R5 district?
Yes.
And do they?
No, they did not.
I'm handing you a copy of a plot plan that has been previously marked as Exhibit A6. I am also going to be handing you a copy of the regulations for the R5 residential zoning district. I'd like to have this marked as Exhibit T3.
Whoops, sorry. And this is T3, right?
Correct. And looking at Exhibit T3, if you turn to the second page, Section 280-35, Area and Height Regulations, are those the dimensional regulations that would apply to Mr. Keeley's student home?
Yes.
And under the student home requirements, he must meet the single-family detached dimensions under the R5 regulations. Is that correct?
Yes.
And looking at those regulations, what is the minimum lot area for the lot for a student home?
Single-family detached is 5,500 square feet.
And does he meet that requirement?
No, he does not. The lot area is 5,160 square feet.
Okay. And you calculated that based on the dimensions shown on Exhibit A6?
Yes.
And how about the minimum lot width? What is the requirement?
That is 55 feet.
Does he meet that requirement?
No, the minimum lot area is 43 feet.
You mean the minimum lot width?
The minimum lot width, I'm sorry, yes.
On the 210 property, it's 43 feet.
Yes, that's correct.
And moving down to subsection 3, front yard, the minimum front yard is 25 feet, is that correct?
That's correct.
And does he meet that dimension either along Landover or Brook Street?
No, on Landover, the front yard setback to the porch is 6 feet, and on the Brookside, the front yard setback to the porch is 8 feet.
Skipping. Regarding the side yard and rear yard, does he meet those requirements?
There is no side yard, because the side yard would be the side that he's attached on.
Okay.
And the rear yard, he does meet that. His rear yard is approximately 44 feet, and I believe it's 25 feet is the minimum. 20 feet, excuse me, rear yard is 20 feet.
Okay, going back to Exhibit A3, which are the student rental home requirements. Have you been out to the property?
Yes, we were out to the property.
When you were out to the property, did you see any buffer yard along the rear of the yard or the side yard?
No, we did not.
Did you see any sort of landscaping that would be acceptable buffer for a student home?
No.
And did you independently confirm that there were 4 students living in this house?
Yes.
Did you speak to those students?
Yes, I did.
And do you know whether or not, or do you agree with Mr. Keeley's statement that there's 2 paved off-street parking spaces?
I'm not really sure if there are 2 there. There is a paved area in the back. When we were there at the property, there were also cars parked all over the grass.
Has Mr. Keeley ever applied for or obtained a annual student home rental license from the township?
No, he has not.
And has he ever provided, did he provide any sort of information prior to your issuance of the enforcement notice regarding the number of students at this home?
No.
And lastly, I'm going to show you Exhibit A9. These are the photographs that were previously marked. Do these photographs properly depict the property.
Yes, they do.
Did you take these photographs, or were they provided to the township?
I believe they were provided to the township.
Was that by Mr. Keeley?
I believe so, yes.
Thank you. That is all I have for this witness.
Mr. Keeley, would you like to cross-examine the witness?
That a complaint was emailed in?
Yeah, I believe an anonymous complaint was mailed to them.
Stand up.
What was the complaint regarding?
The complaint came into our police department on an anonymous tips form. The tip said there are 4 students living in 210 Landover without a license or permit. They are allowed to park their cars all over their backyard.
Okay. I'm just wondering how they knew they were students.
I can't answer that.
Okay. I was not made aware of that.
Yeah, I don't think that's relevant to the case, how they knew they were students. And you've essentially admitted to many of the violations, so
I'm just making
that's
a
not,
point.
let's stick to what's relevant, okay? That it? Are you done, Mr. Keeley?
Yes, yes.
Now we'll see if anybody would like to be heard. And you needn't stand up and say what's already been said or already discussed. I mean, I'd like to dispose of this in an efficient manner, but if you have something to add and if you live within 500 feet of the property and you want to be heard, come up, identify yourself to the microphone, be sworn in, and then we will hear you.
Ma'am, if you'll raise your right hand, you do solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, nothing but the truth.
Yes, I
State
do.
your full name and spell it, please.
Margaret,
Please state it into the mic, ma'am.
I'm sorry.
Either mic.
Margaret Young Martin. I live at 206 Landover Road. My neighbor is here from 208, next door neighbor to this gentleman, but she doesn't want to speak at this time. But I just wanted to bring it to your attention that it is a problem in our community that I've lived there since 1988, that Radnor Township has allowed all these student housing. It's just getting worse. So to have another house in this neighborhood and now on Landover Road is terrible for our community. I have an 11-year-old granddaughter who lives there. There's other children that live in the area. We have these transient students. I'm so sorry for Villanova, but they are in and out, and it's not healthy for our community and for our children. They're unruly. If you go by 210 right now, you'll see empty beer cases on their front yard where they're partying. I've had an experience where they had parties behind me and gentlemen urinating publicly from my view.
From this house?
Not from this house, but
Well,
I'm just
that is-
saying from the neighborhood.
At least you have to stick to what's relevant, ma'am.
Okay, I understand that. My neighbor who lives at 208 lives alone at the moment. Her sister is ill. A lot of noise coming from the house late at night because it is a twin house. And, anybody who's lived in a twin house knows that, you have to really.
Is this noise you've heard?
This is noise that she's reported
But
to me.
you can't testify
Okay.
as to what she's told you. She's
Okay.
here to testify.
Right. So I just wanted to bring that to your attention, that it's not to the advantage of our community to have another student house.
Okay, thank you.
You can leave it on.
Yeah, the mic that's mounted works, or you can use that one, and just make sure the button is on if you use the wireless, either one.
And ma'am, if you'll raise your right hand, I'll swear you in. You do solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, nothing but the truth.
Yes.
State your name using the microphone nice and loud and spell it.
I am Grace Lambert.
You have to use the mic, ma'am.
Yeah, I am Grace Lambert.
And Lambert,
Lambert.
spell that.
Lambert. So I'm representing Melita Walters, who is my sister and is the owner of 208 Landover,
You're representing her through what authority, ma'am?
because she is disabled.
Yeah, but you can't testify for someone else.
I live in the house with her.
Okay, well, you can testify as to things that are in your knowledge, but you can't testify for her or represent her. You can speak to things that you know about personally. And since you live there, you do have standing. So just speak for yourself.
Yeah, I know that there are 4 students there, and there is noise, which is annoying. And just now when I was leaving, it's a twin house. So, it's just the walls that separate us. So whatever goes on over there, then I hear, which is very disruptive, especially at night. Loud music, noise, and, students. It's annoying. And I honestly don't think that a twin house, one side of it should be a student house, because students, they can be loud and disruptive at times. So I'm thinking that it would be unfair to my sister, who is a sick person, to have all of that to deal with. She has to be downstairs in the living room because she's that disabled. She can't be in any bedroom. So,
Thank you.
Thank you, if that's it. Anybody else want to be heard?
Mr. Chairman, would you entertain a motion?
Well, I think we have to sever it first. I'd like to entertain a motion on the issue of whether or not we affirm or overturn the order that was issued by the zoning officer.
We actually haven't had people move the exhibits be made part of the record. I think we ought to. You do, Mr. Keeley, do you move that your exhibits be made part of the record?
Yes.
And Mr. Nelson, do you move that the township's exhibits be made part of the record?
Yes, and I just want to, indulgence of the board, I'd like to make just one statement in conclusion.
As long as you do it into the microphone.
I shall. I just want to state that there are several non-student but rental properties in this area. And one of the reasons why the township is opposed to this application is we do not want to see all these other non-student rentals try to come in and become student rentals, because as the neighbors have testified, it is very disruptive to the non-student population in this area. So thank you.
Do you have anything you want to sum up? No. Well, like I said, the first item to be decided, if someone wants to make a motion, is whether we affirm or overrule the enforcement notice issued by the township. Any motions to be made?
Chairman, I would move that the enforcement notice dated September 23rd, 2014, regarding the violations at 210 Landover Road, Bryn Mawr, Pennsylvania, be affirmed.
Second.
Having a motion and a second, is there any discussion on the motion? No discussion. Call for a vote. All in favor of affirming the enforcement notice, say aye.
Aye.
Aye. All opposed, say nay. The motion is carried unanimously. The enforcement notice is affirmed. Now, the second issue is whether we grant the special exception, and the first issue to get to before that is whether we grant the necessary variances so that the property will qualify for the special exception. My calculation, it would involve variances under subsections D, F, H, J, L, M, N, O, P, Q. We hit most of the alphabet.
To make a motion that we deny all requested zoning relief.
Do I have a second? Second. Any discussions on the motion? I just want to say that by your own admission, sir, and by your own testimony, you do not qualify for special exception for many, many reasons. And it's just unfortunate you didn't start the process by going in and seeking the license, because that would have brought all this to your attention before the proverbial fat was in the proverbial fire. So that's the end of the discussion. All in favor of the denial, say aye.
Aye.
Aye. Any opposed? Say nay. No opposed, unanimously carried. Relief is denied.
Thank you.
Just leave those off so I can take the leases and get the spellings of this.
I certainly, yeah, let's
And
give you
maybe get a
the,
copy of those rules and regulations that Mr. Butler read.
oh, that's, yeah, A3.
I'll do it.
Yeah, I wouldn't mind one.
We're going to take a 5-minute recess and be back soon. Property located at 503 West Lancaster Avenue and Zone C2. Seeks a variance from code section 280-122C and 280-119J for 2 projecting signs, each with an area not to exceed 13 feet 6 inches. I guess that's square feet, right? And height not to exceed 15 feet. Mr. Brosman, welcome.
Yes, good evening. George Brosman representing the applicant Village Associates, which is a Pennsylvania limited partnership that owns and operates the shops at Eagle Village, which is a shopping center that I'm sure you all know, located at Lancaster Avenue and Eagle Roads. With me is Donna Torpy. She is the general manager of the shopping center, and Jeff Martin, who is a principal and an architect with JTA Architects, and they'll be my witnesses this evening. We're here, as the notice indicated, seeking relief for 2 projecting signs that would be attached to and identify what the center is calling the new barn at Valley Forge Flowers. That's located in the northwest corner of the shopping center. Donna will explain in general terms the need for these signs, and Jeff will be providing you with some of the details about the signs and some more of the specific reasons for the signs. For the record, if it's okay with the board, I've handed out the exhibit package that I have, and I'm going to be referring to these exhibits. They're all pre-marked. A1 is the application that I filed, and we'll be making reference to that. I want to emphasize, you'll hear this in the testimony, the proposed signs that we have here, the 2 signs, meet the size requirements and the height requirements for this building in this district. The issue is that they're projecting signs. Projecting signs are not provided for in the C2 district. So that's why we need the relief, and that's the relief we're seeking.
Some of us have been down this road with you before with this very
Yes.
same project. The board has changed quite a bit since then.
I think you're the remaining member.
Am I the only one that was around then?
Oh, were you?
Okay. And
Okay.
as Brad heard as an alternate, and of course John was our solicitor then, but we've been down this road before, so.
Right. So
Okay.
our basis for relief is the same.
Just one thing. I notice your exhibit package, some of them are labeled A2 and so forth, and others just have a tab number. I assume you want to make the A and then the corresponding tab numbers for each one of the materials in your packet?
Right.
Okay, and this would replace the application that we have, so this is the authentic document?
Yes.
Thanks.
So those of you that were here the last time we were here in appeal number 2850 will recall that basically the reason the relief was granted for the other projecting signs was we believe the center has a unique design and layout. It's got multiple buildings that are oriented toward one another with multiple internal drives and walkways rather than the typical strip shopping center. So that is what drives the need for these projecting signs to identify certain of the buildings. In 2011, in appeal number 2850, the board recognized that these unique conditions did form a hardship that would allow projecting signs on other buildings within the center. So it may help expedite things if the board is agreeable. Maybe we should incorporate the record, I was thinking, from that appeal, 2850 into this, although it's not critical. I'm prepared to have my witnesses
Well,
go.
my only reluctance to do that is that the majority of the board wasn't on the board at that time, and I think they deserve to hear the case and ask the questions.
That's fine.
If it were just me, I'd say sure, but I don't think that. Let me ask you a question, George, about that building. Is that the building where they had like functions and meetings before?
Yes.
They had like all different community events and
was
things?
called the,
So it's that
Village
building,
Hall.
Okay.
And it's now been rehabbed into it's called the barn at Valley Forge
Of
Flowers.
course, the excerpt of the plan that was on our exhibit on the application didn't have a north arrow or orient us to the street, so I was guessing that that's what it was, but now I see there where Lancaster Avenue is.
Yes.
Okay, good.
You're exactly right. That's the building.
I think what we did last time is we did away with all the technicalities to the point where we agreed that it's a projecting sign you're asking for,
Yes.
which isn't allowed under this section of code, but would be in the Wayne Business District. And the question was, did we consider this sufficiently like a downtown area so that we could let you do that kind of a thing? And by the way, for the purpose of informing other members, what we did last time was we gave them relief from certain sections of the Wayne Business Overlay District applying to projecting signs, and other than that, they agreed to fully comply as though they were in the overlay district. We gave them relief with regard to a certain size of certain signs, and
There were
maybe height
several.
or something. There were just a couple things, and everything else they agreed to comply fully as though it were in the overlay district. So that's where we wound up before, but it's up to you where you wind up there now.
Yeah, and I think one of the reasons that was done was because those standards for projecting signs in the Wayne Business Overlay District, they have things like the sign shouldn't swing and how they should be mounted and things like that. So I think the board and the applicant agreed that that would be a good way to, make sure all of those things, to the extent applicable, would be followed. So we have, actually at A9, we'll get to it, I took the WBOD projecting sign provisions that the board had attached to the last decision, and
There's a mistake on that attachment, by the way.
It
They
didn't
left
have-
off the last subsection.
Right,
That
I
was in
noticed
the
that.
code, and I do notice you're calling for an illuminated sign, and that's not allowed with the projecting sign.
Well, that's interesting because I put in Exhibit A9 to try to make it a little easier, and I did include M. And I have on this A9 that Jeff Martin will go through whether we comply or don't comply with the signs we want to make it easier for the board. I will note that with regard to M in the Wayne Business Overlay District, the definition of illuminated signs in the ordinance says that, in the sign ordinance, says that it's essentially an illuminated sign if the light source comes from within the sign itself.
Yeah, if we were not talking about a projecting sign under the Business Overlay District, you're right, you can't have an internally illuminated
Right.
sign, but you're not necessarily prohibited from having an illuminated sign. But
Right.
in the section on projecting signs in the Business Overlay District, you may not have an illuminated sign,
Well, I
if it's
guess-
a projecting sign.
Well, that's the question, I guess. If it says it may not be illuminated, does that mean it's not illuminated if it doesn't meet the definition?
Yeah,
of
there's never a
illu-
definition in here that says illuminated only means strands illuminated. That issue you're raising is in the general sign ordinance.
Right.
That would apply to a commercial district.
But I would think that would apply back. But-
Okay, we'll deal with that when we
But
get to
however
the
you deal with it,
discussions,
we
yeah.
would like to have these nice lights on the
Okay,
sign.
let's go on with the case. and-
Well, with that introduction, if there's no questions for me, I would like to have Donna sworn in and go through her testimony. Donna?
And ma'am, if you'll raise your right hand, do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, nothing but the truth?
I do.
State your full name and spell your last.
Donna Torpy, Torpey.
Donna, what is your connection to the shops at Eagle Village Shopping Center?
I am the general manager
And how long have you held that position?
since January 2009.
And as the general manager of the shopping center, do you have authority to proceed with this application to the board on behalf of Village Associates?
Yes, I do.
And at Exhibit A2, is that a copy of a written consent that is signed by the partner of Eagle Associates that confirms your authority?
Yes, that's right.
And is that still in effect?
Yes, it's open-ended.
And do your duties include leasing, capital improvements, and the day-to-day operation of the shopping center?
Yes, it does.
And do you have experience other than being the manager here in retail property management?
Yes, along with those other duties, I'm also accounting and financial professional. And I started out in shopping centers in the accounting and financial area in 1997. I was chief financial officer of a portfolio of shopping centers that were community food anchored shopping centers throughout the East Coast. And all the duties that I hold at Eagle Village Shops are the same duties that I held for this portfolio.
Thank you. Now, I'd like to refer to the description of the shopping center at Exhibit A1B, and I put a larger copy here up on the table. Is this a site plan that shows the current layout of the shopping center?
Yes, that's our most recent Alta survey.
And the building in question, there's a large square put around the building, is that correct?
Yes, that's considered Building 10. We have 14 buildings. That's Building 10. That was the former Village Hall, which was the Community and Banquet Center.
And in the exhibit package, there's an Exhibit A3. Put this up here for a second. Is this an aerial view of the shopping center?
That's an aerial view that shows frontage on Lancaster Avenue and on the side from Eagle Road, yes. And then it goes back towards residential housing.
Now, you heard me describe in my opening remarks some of the unique layout and design of the shopping center. Could you describe that?
Well, this is like, from a commercial shopping center point of view, this is a shopping center like no other. It's totally unique, even from what you might call a lifestyle center, even from that point of view. This was a shopping center that the owner had put together parcel by parcel to create this village environment. A typical shopping center would not have this number of buildings and create lack of visibility from the road as this shopping center does. So from a unique point of view, yes, this shopping center today would not be built.
And it has various internal roadways and sidewalks.
Well, there's there's 3 entrances, 4 entrances from Lancaster Avenue. The buildings are positioned in such a way that only the ones closest to Lancaster Avenue are actually seen. As you go further back into the shopping center, they can't be seen at all. So the building in question can't even be seen within the shopping center itself.
Does this unique design present challenges to the shopping center and special needs for signage?
Well, it does. It's the same problem we had when we first approached Radnor Township. The lack of visibility, the difficulty it is in driving through the shopping center, trying to find a location with these multiple buildings, the flat signage, particularly at the time, there's very specific type rental units that aren't really technically a retail unit. They're like very small boxes. And they're tucked in such a way that what we found is the businesses did not do well. They did not benefit from the traffic like the Wayne Business Center does. They're really destination centers. And so certain locations, in order to be able to find them, we were trying to minimize the amount of turnover in the businesses because they weren't succeeding. And so certain locations, signage, and of course that's the #1 complaint with our tenants, is nobody can find us. So, and we're not, we're very limited in what we can put on Lancaster Avenue. So what we're trying to do is help our customers navigate within the shopping center itself, and not just give up and drive away. So what we found is we had certain locations that were a challenge, that had repeated businesses that were constantly turning over for lack of sales. And so the projecting signs was a way to help people find these businesses. At the time, when we submitted to that, the Village Hall was a community center, and we didn't have the need to ask for signs on that building. So what's happened is trying to not only present a pedestrian method to find the businesses, but also for automobiles to travel to find the businesses is the challenge in the shopping center.
Thank you. How would you describe the quality of the architecture, the landscaping, and the overall general appearance and upkeep of this shopping center How does that compare to other shopping centers that you're familiar with?
Well, as I said earlier, that this shopping center would never be built in the way it's designed right now. It doesn't have the frontage that commercial shopping centers would require. It's too far set back from the main artery. But the buildings themselves were designed, as this shopping center was created, to create a village effect, a very unique shopping experience, something nowhere else in Delaware County or anywhere as far as I know, but unique to Radnor Township. And therefore, the efforts that we have put into it was to enhance the community at large and the businesses within it.
So is the architecture and the landscaping that you do here more than you would see in a typical shopping center?
It's very much more than you would. Typical shopping center, even from a lifestyle center point of view, might have one or two big box center buildings, and then small buildings coming out from that between those boxes. These buildings are scattered. They block each other. So it's not unlike any shopping center that I'm familiar with.
Now, during your time as manager, have you overseen some of the upgrades that have been made to the shopping center?
When I first came in 2009, the shopping center was in decline. And of course, at that time, we experienced the worst recession we've ever seen. The other thing that's unique to the shopping center is we don't get what we call credit tenants that have large amount of money behind them, like a CVS or something, or a Chico's or things of that sort. These are mom and pop shops for the most part, or the regional businesses that might have another unit in another location. But for the most part, we cannot put in what would be a large credit tenant. So these are really businesses that we're trying to help and promote within Radnor Township, are all really small businesses.
Now, turning to Exhibit A4, is that one of the signature projects you did at the Valley Forge Flowers? Is that one of those local businesses?
That business is actually one of the owner's businesses. Valley Forge Flowers moved from a very small location into, this was our very first rehabilitation of a building to create what I felt was needed in the shopping center to promote the viability of the shopping center was an anchor tenant, what we call an anchor tenant, a main tenant, a big draw, that in turn helps the smaller businesses. So the owner, recognizing this and that the Valley Forge Flowers business itself was growing leaps and bounds, we needed a showcase business for Valley Forge Flowers and to act as an anchor for us to have a really special building to draw people to the shopping center. And Valley Forge Flowers has indeed done that for us.
Now, have you done another signature piece that we're here about tonight, which is the barn at Valley Forge Flowers, which I have a picture of at A5. Have you done that very recently?
That was just completed, and the CO obtained in this month. It's opened up to success, but the problem is what I was able to convince the owner was that there is no retailer on earth who is going to take that building that far set back into the property. So as such, it was very difficult. I was able to convince that having the barn at Valley Forge Flowers was a much needed use in the township, and that it is, provides an outdoor garden center. Also, too, the business she was outgrowing the space that they were in and needed a second location. So the owner, really, I think it was really only the owner that would make an investment in this, number one, in the shopping center itself, and number two, in the Valley Forge Flower business. And so it was not making it as a community hall any longer. There was too much competition, and it had really became of age, and was really not much more we could do with it. So by making a unique structure and setting it apart from Valley Forge Flowers by creating, again, another showpiece within the shopping center, within the township, to draw people to the back. But I have to tell you, even the side, calling it the barn, people will still drive in and they don't know where to find a thing. So that's why signage is important to this shopping center.
Now, you talked about the unique layout and design of the shopping center. I think you've hit on this, but just for the record, are those problems especially acute for the barn building and this location, this part of the shopping center?
Well, it's especially acute because if you come in, how do I describe this, George? It's like,
Refer to the road that you're coming from or the building?
if the entrance from Lancaster Avenue going in between,
Excuse me, ma'am, you have to back off the mic a little bit. You're,
okay, great.
get a pop filter.
Let's just for sake of argument say where the barn is, that's north. Okay, so we're traveling from south from Lancaster Avenue. All directions coming from Lancaster Avenue are traveling south to north. And it isn't until you get into the center of the shopping center that you even begin to see that there is a building there. If you come from Eagle Road, and Eagle Road you're coming what would be east to west, it's not until you hit into the same center that you would even see the building. So it's not visible from either Eagle Road or any parts of the entrances on Lancaster Avenue.
So it's in the rear far corner of the center?
Yes.
And it's behind several other buildings, as you can see here on the plan, correct?
Correct. The buildings themselves obscure. Valley Forge Flowers, the existing Valley Forge Flowers is actually perpendicular to the barn. So as someone comes up approaching Valley Forge Flowers building, and if they look west, they would see the building. But the most of what we find so far that the traffic comes in, they first go to Valley Forge Flowers. They know where that is, just from having been there a number of times. But I'm concerned about what we're hoping would be for this business to succeed would be new customers who aren't familiar with the Eagle Village setting, so that we would draw in people from outside the area and hopefully create this buzz, this energy that would then transform into the businesses that really hurt, and bring that energy over to what would be the businesses that are very set back from Lancaster Avenue.
Thank you. That's all I have for Donna.
Thank you, George.
Are there any questions before I call the next witness?
This barn, this is quite a bit taller than the other buildings, isn't it? This isn't the kind of thing where you could pull in and see a barn sticking up behind the building?
You can't, no.
Jeff will go through this, but if you look at A8, some of these photographs,
So you're going to tell us about like the sight lines and the elevations and all that? yeah?
A8C, for instance, Jeff will get into this, but
Okay.
you can see like
No, I don't want to take you out of your order.
All
It's
right.
okay. I just want-
No, I was
the
really.
testimony will show that it's completely obscured by other buildings, and there's a couple of pictures that do a nice job of showing that. But Jeff will get into that. Could I have you, Jeff, come up and get sworn in?
And if you raise your right hand, you do solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, nothing but the truth.
I do.
And state your full name, please.
Jeffrey Martin, M-A-R-T-I-N,
And Jeffrey is spelled.
J-E-F-F-R-E-Y.
Jeff, are you a licensed architect in the Commonwealth of Pennsylvania?
Yes, I am.
And you're a principal at JTA Architects,
Yes,
based here in Radnor Township,
yes,
based here at the shops at Eagle Village?
I am.
And in the package at A6, is that a copy of just a summary of your professional qualifications?
Yes, it is.
And your office is there, so you're obviously familiar with the shops at Eagle Village?
Yes,
And do you have experience with other retail uses?
Yes.
And have you been the architect for various projects at the Eagle Village shops,
Yes, I have.
including Valley Forge Flowers?
Yes.
And were you the architect for the barn project?
Yes, I was.
And did your firm prepare the plans for the signs that were approved in Appeal 2850?
Yes.
And you testified in that matter?
Yes.
And have you prepared the plans for the two signs that we're proposing here tonight?
Yes.
I would like to offer Jeff as an expert in architecture.
He certainly knows more about it than we do.
Jeff,
You testified before, didn't you?
I did,
Yeah.
yes.
Jeff, in the hearing on Appeal number 2850, Donna testified about it earlier, but you had also testified about the unique condition of the shopping center and the signage challenges presented by those conditions. Do you recall that?
I do.
Have conditions in the shopping center changed since then in that regard?
No.
So if I were to ask you about those conditions, would you testify again to their existence?
Yes, I would.
And they would be similar to what Donna had testified to?
Yes.
And in that application 2850, you had testified about the need for internal signage, including projecting signs. Do you recall that?
I do.
Have the conditions in the shopping center that drive the need for projecting signs changed since the last time?
No.
If I were to ask you about those conditions, would you testify again to their existence?
Yes, I would.
Moving on to the proposed signage, I'd like to draw your attention to the application that was filed A1. It's near the end of A1, Exhibit E. Is this essentially a part of the site plan that we've been talking about that has put certain numbers on some of the buildings?
Yes, it is.
And then on the next page, there's a few pages that are Exhibit A1F. Are these the details about the proposed signage?
They are. A1 relates really to a wall sign. It gives the required...
A1F, the first page.
Correct.
Excuse me, I couldn't understand.
Yeah, could you switch mics? Maybe the other mic would be better. And you're...
Is that better?
Yeah, you've got a more robust voice than the last one, so hold it like a foot away.
You want
Let me
to
try
try
this
Or you
one?
can hold it a foot away, I think it'd be
Okay.
fine.
Does that pick it up?
Much better. yeah.
Okay. Yes, Exhibit F is the data for a wall sign.
And then that's the first page of F. And then there's a couple other pages. Are they the particulars about the proposed signs?
Yes, they are.
Now, referring to, go back to E, please. And as you choose between E and F, can you describe for the record the details about these signs that we want, the type of signs, the location, their size and height?
Well, if you are looking on Exhibit E, you'll see projecting from the building a little round circle. That's actually our silo and entrance to the building.
And that's Building 10 on this
That's
exhibit?
Building 10, yes. We would like a projecting sign coming from that so that if you're in front of buildings 12 or 13 and look in that direction, you'll be able to see that sign and have that draw you toward that. If you look at Building 10 on, I guess, what would be the east side of the building, right? If you're driving up from Building 6, we want a projecting sign there so that that sign will be parallel to your windshield. We want it so that you'll see that. A wall sign would be parallel to the road, and you wouldn't be able to see what it is.
Okay, and just for the record, can you, referring to A1F, describe the size and the other details about this sign?
The sign is a round sign, 13.6 square feet, approximately, what do we have, 48 inches across. And we want that mounted on an aluminum bracket to resemble an old iron bracket. And the top of that would be at 15 feet above the ground, which is our wall sign maximum height.
And Mr. Cutler asked about this, but can you talk about how these signs would be illuminated?
Yes, these would not be internal signs. These would be carved urethane signs, and these would have gooseneck lights coming off the sign bracket. And we have, I don't know if this was entered as an exhibit.
It wasn't, but I could mark it.
Excuse me, is urethane a kind of plastic?
I guess technically, it would be a kind of plastic.
That's
It's
another
used in the sign
prohibition there,
industry now
George.
instead of wood because it doesn't rot.
Yeah. I'm not debating the wisdom of using it. I'm just saying that that's another thing specifically prohibited in the projecting signs. So these are things we'll just need to deal with
Right.
at some point. Okay.
So you've gone over the illumination. Now, if these signs were wall signs, which they're not, if they were, we wouldn't be here, but if they were, would they meet the size requirements and the height requirements?
Yes, we would be allowed up to 50 square feet for signage, and we're asking for a total of between 26 and 27 square feet total. And the maximum height is 15 feet, and we want to match that.
Will these be the only exterior signs on the building?
Yes.
And you've stated this, but just for the record, A7 is a chart that just says there would be the two signs on Building 10 with the size of 13 feet, 6 inches.
Yeah, 13.6 square feet each.
Right. And
27.2 total square feet.
in terms of size and location and design, are these signs designed to aid both pedestrians and motorists that would be within the shopping center?
Yes, and as I was pointing out in referring to buildings 12 and 13, that we want these signs to be seen from some distance. Unfortunately, they won't be seen from anywhere off the site. From Eagle Road, you won't be able to see them, nor from Lancaster Avenue. But we are trying to capture people from within the site when they're going to other stores, such as the little house shop or the row of shops down at Building 6.
Now, I'd like you to refer to the photo package at A8 and just take you through these. A8A, which is up there, could you show what is in that picture and if one of the sign locations is depicted?
That is our entrance silo, and the sign would be mounted right above that entrance pergola, and right where you had the where you see the wire sticking out is our 15-foot mark.
And
all ready to illuminate the sign, is it?
We have high hopes.
And A8B, can you tell what's in this picture?
Yes, we're looking at the east end of the building, and you'll see you'll see a wire directly above the triple window.
And that's the location
And
for the
that's also at
second
the
sign?
15-foot mark. And again, we have high hopes.
And can you go to the next photo?
This photo is taken from...
This is, for the record, A8C. Describe what that photo is showing.
The photographer would be standing in front of, I guess it would be Building 11, the little house shop. And the little house shop and Valley Forge Flowers is to your right. And you're looking down past Silver Spoon, right in front of the barn. And you'll see the barn is behind that yellow building, but you can't see it in this photograph.
And
then
to A8D, tell us where this...
We are standing really in front of Building 6, and the building that you see in that picture with the tree is building number 3, and the barn is behind that. Now, if you look closely toward the left edge of the building and the roof line, you'll see a glimpse of the roof over that building, but that's all. That's all you see.
And
So that building's pretty hidden by our other buildings.
let's turn to A8E.
E is taken if you're between Building 3 and, no, excuse me, you're in front of Valley Forge Flowers.
In front of the house
Yeah.
shop, yeah.
I was ahead of you with pictures.
Right.
Yeah, you're in front of Basically, you're basically in front of the bay window at Valley Forge Flowers.
And you're looking down toward the, you can see the silo in the background there?
You can see the silo in the background, and you can see an SUV in the foreground demonstrating why we need the signs to be fairly high.
And does this photo also demonstrate, why the sign needs to be projecting?
Yes, it does.
And that's so you can see it as you look down that way?
Yes.
And moving on to A8F.
This is where I was a moment ago. This is if you're standing in front of Building 6 and you're looking up and catching kind of a side glance at the building.
So the side of the barn that's in this photograph was the side of the barn that was in A8B, is that correct?
That's right, the east side.
So does this demonstrate why you would need a projecting sign there?
It does.
And why would that be?
Well, we're looking at quite a distance. With this photograph, this was probably early in the morning before the parking lot filled up, so we don't have the large SUVs in this photo that are usually there. But the one car that's there does show you that we do need to clear that height.
And if it was a wall sign, it really would be of no utility at all,
A wall sign
correct?
would not be seen at all.
Okay. I want to shift gears to the Wayne Business Overlay District standards for projecting signs. As Mr. Cutler noted, in Appeal 2850, the board applied certain of the Wayne Business Overlay District requirements for projecting signs that are found in Code Section 28053.15 to the projecting signs that were approved in that application. Are you familiar with those requirements?
I am, yes.
And
George, I'll tell you what would be helpful to us. I think as you go through each one of these, you could talk about whether you're going to comply or not comply, and if not, why you need not to comply.
Sure.
So that way we can kind of tick it off in our heads.
Makes sense.
Sure.
Okay.
So
Mr. Rosen, what exhibit is that again?
the one
It's A9.
A9.
It-
I found it.
It's right out of our code.
No, I didn't find it. Okay.
So there may be a mistake on this about the if you think that that material that Jeff was referring to is
Yeah, let's just deal with them one at a time.
When we get to
But we'll
J.
get to that. So what we have at Exhibit A9 is a cut and paste of 2805315. And Jeff, could you walk us through each requirement and indicate, yes or no, whether these signs that we're requesting would comply with the applicable requirement? And
Mr. Brosman, I noticed the title in the Wayne BOD in effect on December 19th. Technically should be today,
That's right.
so we'll alter that.
And I assume it'll also be in effect tomorrow, but
Yeah, but still,
It has to be. The commissioners aren't meeting today.
that's right. But thank you for picking that up. So refer to each letter.
Okay, A, yes, we can conform to A. B is restricting to 12 feet above grade, and we would like to go to 15 feet. So that would be a no on
So you're
B.
not lower than 9 at any part.
Not lower than 9, correct,
But
because
you
we have
want
a,
to push the upper limit. And the reason is, I presume,
we have a sidewalk
Was-
under both locations.
And you want to, you
And we want
mentioned
the height to see from distances
you've got to
within the
get
village.
a sight distance, right?
Right. We want to be able to clear some of those taller vehicles.
Would anything shorter than that as a top solve the problem?
No, I don't think so. Just given some of the vehicles that are in there and trying to see with the topography of the ground, we have a lot of foreshortening of views.
C we're up to?
C, we would not be projecting over a vehicular way, we'd be projecting over sidewalk, so we're fine with that. D, we would like to be larger than 4 square feet. We would like to be 13.6 square feet.
Is that the minimum that will accomplish the purpose?
Yeah, we did spend a lot of time walking around looking at sign sizes and standing back distances in the village to establish what we thought would be the minimum size sign to work there. So it's a combination of the scale of the building and the visibility from the distances Even from the door of Valley Forge Flowers over, it's quite a distance, and that's really the closest building.
Okay, what are we up to?
E.
The sign shall be no wider than 30 inches. We would like to go wider than that. We're showing our sign at 50 inches.
Is that necessary in order to have the right legibility?
It is, and if you look at the sign, the handout, our letters are still smaller than we would like. Ideally, we would have liked this sign larger, but to get anything visible on that, it's still a very minimal size. F, only one sign projecting per face, we're fine with that. G, pinning the signs, yes, we're fine
You
with
didn't
that.
show that dimension on the drawing.
I'm sorry, which dimensions?
The pinning distance. It's got to be between 2 and 6 inches. That wasn't shown. I didn't see it.
Actually, what we have, there's a pin back here. This is a rigid sign, and we have a pin on the side at 9 o'clock, we'll say, and we have a pin at midnight. So it's pinned in 2 locations.
But is it at least 2 and not more than 6 feet from the wall there where it's pinned?
Correct.
Okay, good.
2 inches, not 2 feet.
Correct, 2 inches.
So we're up to H.
H, we are more than 12 feet between the 2 signs, so we're
we
fine
would
with that.
comply with that.
I, we're talking about the materials being, we're really not a painted wood. We're not an antique metal for the signboard itself. We are metal for the bracket, but we're talking about a carved urethane for the signboard itself.
Now that I says appropriate materials include.
Yeah, this is just examples. You don't have to
Okay.
be one of those.
So then
The
J, the
issue is you can't
prohibited
be, we
might
can't be one of those under J.
Right, the J might be the issue where, yes.
It says
Please take a mic.
plastic. I would not allow plastic signs in the shopping center. But what I do, which is actually more expensive than wood, is the high-density urethane. And the high-density urethane is made out of plastic plate particles, I guess, if you would. But it's not itself plastic. You're able to carve it. You're able to treat it like wood. And so what I found is that the high-density urethane weathers better. It lasts a lot longer, but yet it has the properties and look of wood. So it is.
That's what I was going to ask you. If you were standing 20 feet away on the sidewalk, does it look like wood?
Yeah, in fact,
looks
if you
like
tap
wood,
it, if you're up
yes.
close
It's
to
not
it,
shiny.
Even if you're
or-
close, it looks like, no, it's not plastic in nature of just plastic signs. I don't permit plastic signs, but this
But
looks very
is there any
good.
dispute that this material is not a plastic?
It's not 100% plastic, it's plastic particle base. But
what
it's not a
else other
shiny
than plastic
surface,
is-
it can be painted.
I understand that. What else other than plastic is in this material?
That I couldn't tell you for sure. I just look at it from the appearances.
I'm
and
sure
if
it's got some kind of matrix,
Yeah.
that the particles are.
I understand that.
particle
All-
board would be with-
This is not a complicated question.
Yeah.
Is it plastic or isn't it plastic?
I like to think it's not, but
Thank you, but
I don't think we have the
frankly, I
scientific
think it's
knowledge.
plastic, isn't it?
but it doesn't work like
I'm
plastic.
not suggesting that it may or may not be appropriate, inappropriate for the use, or looks acceptable to the image that you're trying to
Right.
put together for the shopping center. It's a very simple question. Is it plastic?
I think I would say we probably don't know, but let's
Plastic
assume
base.
that it is and request relief
Yeah.
from it so that we don't get caught short.
Yeah, right.
It sounds like it has
I don't
plastic.
know the chemical properties, and I don't want to,
I agree. I don't want you to,
Right.
to
All of you careful
battle,
people are
but
always
not-
trying to figure out what it is we're getting at instead of just answering the questions. This is actually for your benefit in the
Right.
end.
Yeah.
But what's the precise name of the material again?
high-density urethane.
High-density urethane.
So we should possibly change that J to an N if the board thinks it's plastic, and then we would seek relief for that, if the board would be
It
inclined
has
to
been
grant.
so marked on my notes.
Great.
K, the mounting, yes, we will comply with that. L, the signs will not swing, so yes. And M, the signs shall be illuminated. It's saying it shall not be, but we would like to, not internally illuminated, but illuminated with our
We're making an
goosenecks.
M
I'm
and
not sure.
the Y is becoming an N.
Correct.
You're not conforming, you need relief.
Correct.
We would be
I think we-
conforming under that theory that I mentioned, but
The theory that you could cherry pick things from the one sign section versus the other, and
Right.
no, you can't do that.
That's fine, as
As we
long-
did- as we did last time, George, we basically are going to, if we give you relief, we're going to give you relief to do the sign as if you were in the Wayne Business Overlay District, and you agree to fully comply with it, except as specifically
right.
the
Well,
subject of
we
the
would have to
variance.
decide that
Yes.
standard first.
Yes.
We haven't
Right.
decided that yet.
Yes.
As it stands, the standards we're talking about have no application to this case. It's the Wayne overlay district that we're talking.
Yeah, only if that's the way we word the variance, we decide to grant relief.
That's right.
The variance, the efficient way to do it, that we did before, would be to do it by saying, you're given a variance to do that as if you were in the district, except you may vary from the following requirements that would have applied to that district and no others.
It was essentially a condition to the variance.
And I think we were looking at the other way. Could we take the wall sign regulations and make it a
Right.
bracket? So I think that's why you had that.
Right. Jeff, I think by going through this and answering some of the questions, you've hit on most of the standards for a variance, so I won't repeat them, but just to hit a couple of things for the record. Has this hardship that we've talked about, the unique condition of the property and the difficulties with rehabbing this building, has that been created by the applicant in this case?
No, I think the hardships are the shape of the property and the depth of the property.
And the configuration of the buildings that we spoke about?
Yes.
And in your opinion, will the relief in any way alter the essential character of the neighborhood or be detrimental to the public health, safety, and welfare?
No, hopefully an enhancement.
In fact, I think you stated this, but the purpose of these signs isn't to draw attention out on the public roads. They're basically for internal direction purposes.
Correct.
And I think you touched on this, but do you believe these are the minimum variances that will afford relief?
I do, yes.
And one of the points on that is that they are smaller than the 50 square feet that would be permitted for this building. Is that correct?
As a wall sign, yes.
Okay, that's all I have for Jeff.
Okay, anyone else have a question for the witness? No? You would move your exhibits?
Yes, that's my case, and I would ask that my exhibits be moved into the record.
Okay. Anyone else here to speak on the issue? No one else? Their chair will entertain a motion, if someone cares to make one.
People will tell me whether my notes were not as careful as they should have been. I make a motion that we grant the applicant a variance from section 280-122C and 280-119J for two projecting signs, each with an area not to exceed 13 feet 6 inches and a height not to exceed 15 feet, with the further requirement that the signs be installed in compliance with section 280-53.15, presenting limitations to certain projecting signs, except that compliance shall not be required for subsections B, D, E, J, and M.
Bless you.
Second?
I second it.
Mr. Chairman, in granting the exemption from J,
We're going to have a little discussion about that.
you want to specify it's
Yeah,
got to be this
yeah.
this high
Right.
density or a thing.
Yeah, I think now's the time for discussion. And is there any discussion on the issue about the height?
Well, I might want to present another alternative to that,
To what?
to that motion.
Well,
My motion would be we approve the variances as presented. No requirements to follow the overlay district requirements.
Well, the problem I have with that is the reason they designed that section in the overlay district was they wanted to protect against certain issues. Some of these are physical issues like wind, want swinging signs, this and that. And so they thought out this whole issue, presumably with professional advice, on how you can do a professional projecting sign. So we can kind of take that and move it into this, which is kind of its own little business district, almost like it's the center of Wayne, but it's not in that district.
Okay. I'm not opposed to that.
And then just vary it where it needs.
I think there's enough of a hardship, in my opinion, that's been shown that we don't need to look to those rules.
But that would be giving them a broader relief than they've asked for that they need to solve their
No,
hardship.
they need a relief under 280-119 and 280-122
To do what?
to put up those signs. 'Cause
To put up a
it's
projecting sign.
Projecting sign.
Then we'd have to define all these things about projecting signs in our order.
Well, I don't think that's the case, but
In other words, they could put it up out of plastic then. If we did that, they could just make a plastic sign that looks like a plastic sign.
Well-
Because we wouldn't have the protection of this.
we could decide to put those limitations on if we like. From my point of view, I don't think that it's necessary.
I'm just trying to avoid reinventing the wheel. Well, everybody will know what the rules are, except to the extent we give them specific relief from the rule.
Okay.
See?
Well,
It
like I
actually,
said, I'm not opposed to that, but I don't know that the whole exercise is necessary.
okay. But I mean, we're discussing a motion that's been made and seconded.
Okay.
So
I'll
if you
withdraw
wanna-
my
if-
motion that I almost proposed.
I mean, you can make a motion to amend the motion after
No,
our discussion if
that's
you'd
all right.
like, but
That's okay.
how do you feel about that issue? Guys, have any?
We're cognizant of whether it's plastic. I don't think it's plastic.
Well, I mean, none of us are physical chemists. Whether it's plastic or not, we can give you very specific and say, as long as it's made by this and out of this and looks like that, so. But this is discussion, we're discussing it. There's so little attention paid to dialogue in this day of cell phones and texting. No one knows how to dialogue anymore. We're a deliberative body, let's dialogue.
I want to hear, I'm sorry. I'd like to hear more on George's proposal, frankly. So at this point, I don't have a position on the particular motion that's in front of us.
Well, unless
right
there's
now.
a formal motion to amend with detail, we're discussing this motion on which we're going to vote.
And George, are you
If we vote
proposing?
this down, you could make a new motion.
I'm withdrawing my proposed proposal.
I have nothing further.
Yeah, if you look at the prior order and the other case that we had, this requires more carve-outs than the other one did. But it was an easy way where everyone knew exactly what they were and were not getting, and it's a good format, I think, to follow, the way
Yeah.
John did it before, except this time we have to make sure we put M in if we're going to attach the exhibit, because one of the subsections was deleted by accident.
And I think my point was simply, I think we're overcomplicating it. I think there's a hardship involved, and we can grant a variance without looking at any other rules. That was my point, but we'll proceed with the motion that's been proposed.
Okay, now my discussion on this is under B, we really have no further clarification required. We're just going to give them the relief to go to that height. Is that shown in your exhibits, those heights?
Yes.
Okay.
It's on A1F.
In D, we're going to give you the right to use those, if we grant it, to use those dimensions as shown. on your exhibit. We'll incorporate the exhibit into the order. And E, again, we'll incorporate the dimensions into the order as shown on the exhibit. On J, we're going to say that it may be made out of high-density urethane, provided it has the appearance of a wooden sign. Because I think all this was trying to get to is appearance issues.
Mr. Chairman, could that be any more subjective? Well, that's subjective. And I would think that we'd be looking to draw bright lines here and not
Well, if you look at
enter into a subjective discussion as to whether
see, the
it
commissioners
looks like
couldn't do
wood
that.
or plastic or something in between.
But John, the commissioners didn't do that. You see, they're talking about appropriate materials shall include. They couldn't be really definitional either. Carved, sandblasted, or painted wood. I mean, they didn't say you couldn't use anything else you wanted besides those things. They're saying here's some examples because it is subjective. It's really an aesthetic criterion here. That's what we're talking about. Maintaining the look. There's no other reason for this provision.
Isn't there another body in this township that determines what signs look like? Thank you. But my suggestion is we shouldn't be making aesthetic judgments when there's another regulatory body in the township that has already done it.
My suggestion was not to be aesthetic, but to clarify that they can't just use any old plastic. We're going to give them a variance from J1, but we have to do something to limit it so that they're not putting up some clear plastic sign.
Yeah, I think the problem is that this.
We're fine saying high-density urethane.
Yeah, but I think that the problem is that while we have design review board, which, does their, aesthetics, we actually have a zoning provision that overlaps with that, which says you can't have plastic. So that's why we're stuck with the thing.
And we don't have a rendering that shows what it's actually going to look like, do we, that we could rely on?
We do.
And attach as an exhibit?
This wasn't marked because we only had one of them.
I mean,
but
is that exactly what it's going to look like?
I could call this A10.
So you can't tell from looking at that whether that's a shiny plastic-looking surface or a matte surface, or, can you really tell from that?
No. But it's not going to be.
What were the other projecting signs made of? Seriously? Okay. So it's already there.
A citation for the prior signs is not for us. We only have these two signs.
Yeah. And if we just incorporate...
Sounds like we'd win that anyway.
And if we
It's
just
not
incorporate, substantially of the same appearance as what exists now as far as the materials, the problem is 20 years from now, when someone looks at that variance, those signs may all have been replaced. So, really, this variance could last a very long time. So, do you have a better way we can deal with the issue, John, since you object to my subjectivity?
Just make one other point about high-density urethane. It's more expensive than
You have to use the mic. It's not on.
Just use this.
It's more expensive than wood, so my tenants would love very much just to use wood, but wood doesn't last. So the Design and Review Board, that's one of the aesthetics that they have approved, because we still go to the Design Review Board meeting. We needed the variance in order to get the projected signs, but the aesthetics that the Design and Review Board have found repeatedly is the acceptance of high-density urethane because of the appearance.
So you're going to go there after you're finished with us?
Yes, yes.
Okay, then what if we just said that specify the materials high-density urethane as to be approved by the Design Review Board?
Because the Design and Review Board's advisory, though, isn't it?
That then subjects.
That gives them more jurisdiction than they have.
Right.
But I mean, they'll have a better way of specifying the aesthetics than we'll have.
I'm withdrawing any further objection I have to this application.
What do you mean?
Let's go.
I mean, I suggested language for giving that variance. Are you going along with that language?
That's fine.
Oh, okay.
So just, we'll just say that it can be made of high-density urethane. How about that?
And that they may be illuminated as shown by the, not internally illuminated, but illuminated as shown. on
But
the
George, the
plan.
other option is we just take out J and not give it to you. You've already gotten your signs up there already, so maybe the township has already decided that it's not considered plastic.
I would just
And they're
like
free
to
to
say
find.
high-density urethane, because that's what we're going to do, and that way there'll be no dispute
I'm
about it.
fine with either way.
Yeah, I think it's-
I'm still holding my motion, my seconding of the motion.
John Ryan, you're going to have to write this. Okay, so the motion, as clarified by the discussion on the materials, all in favor, say aye.
Aye.
Aye. Any opposed? No opposed? You have your relief,
Thank you.
and may God have mercy on John for having to write this.
I'm going to stay anyway. To do that next case. Good job, thank you.
Thank you, guys. Thanks very much.
We're going to take another 5-minute break. We'll be right back. Nick, the alarm goes off in 10 minutes. It must be a refreshing change to watch us fight with each other instead of with you.
I thought it was discord.
Now behave, my wife is watching at home.
Oh, I know, but I've never heard that anywhere.
You know, it looks like you want to acquire a right-of-way to install a microphone.
Oh.
Okay, everyone's back present. Next is appeal number 2931. The applicant Radnor Chester Road Investment LP, which by now gets frequent flyer points. Property located at 240 Radnor Chester Road in Zone PB seeks a variance or a de minimis variance from Section 280-60B of the zoning code relating to the area devoted to landscaping impervious coverage requirement, and seeking relief from Section 280-122C5AC regarding location of signage in the right-of-way. Applicant seeks any other zoning or alternative relief required pursuant to the plans presented with the application. Mr. Cornelia for the applicant. Welcome.
Good evening, I'm George Brosman. I had left up with Mr. Ryan an entry of appearance form. I would like to enter my appearance on behalf of Radnor Properties 201 KOP LP, Radnor Properties SDC LP, Radnor Properties 555 LA LP, and Radnor Center Associates. These are Brandywine entities that own properties adjacent to and close proximity to the subject property. And I'm going to state that I'm not here opposing this application, but I'm entering my appearance and I'm going to be observing and may have a statement to make at the end.
Mr. Rose, do you have another copy of this?
Yes.
Okay, I'd like to one for the town file. I'm supposed to monitor who things get mailed to.
That's why I did a full writing.
Do you have one? You have one? Okay, I got it.
Now, Peter, you're standing, so I imagine you have something to say, too.
Yes, the township wanted me to just inform the board that the township is in favor of this realignment project, which is the reason why Mr. Gross is seeking these variances and relief. The township feels that the realignment of the driveway across from the school district will be in the best interest of the public's health, safety, and welfare, and that we support this project and the relief necessary in order to make it happen. I am just here speaking this. I'm actually going to be leaving. I enjoy your company, but it's time for me to go home.
But you say you support this project, you mean the specific
yes, we support,
relief requested here?
We support the project and therefore support all the relief necessary to make it happen.
Mr. Nelson, I gather a component is putting a sign in the right-of-way?
It's an existing sign. It's just staying in the same spot.
But it's, then,
The township traffic engineer, Amy Kaminsky, is here, and she is going to be staying, and she would be better able to address that question.
this is a state road, right? Yes, I mean, the point is, this board has no authority to, I guess the board could say we have no problem under the zoning code, but we
Correct,
can't
and
give away any rights that belong to the Commonwealth of Pennsylvania.
Correct, and I'm not overly familiar with why that particular relief is being sought. I'm assuming that there's a zoning section that applies, but
There is,
obviously,
yeah.
but obviously, you know, that's all you can speak to, and that's all the relief that they can be seeking.
And the township has no, is this right-of-way also a township right-of-way as well?
I don't believe so. I believe it's just a state road.
I mean, I think that what I'm coming to is, we could note your lack of opposition, but I don't think the board is in a position to alter any property rights of the public in the right-of-way, whether they be the township's proprietary rights or the Commonwealth of Pennsylvania's.
I don't believe the township's asking you to do that.
We can't, all I would say is if relief is granted, I would recommend that I be allowed to make absolutely sure.
Can we clarify? I think there's a little confusion here that we should clarify.
Need your name.
Alex Tweedy with Nave Newell. I'm the civil engineer for the project.
Alex, why don't you get sworn in, though? Because you're a fact witness. Okay, I'm sorry.
Like I said.
He was
So
gonna
I just
explain it.
want to enter my appearance on behalf of the township. The township supports this application, and thank you very much. I wish to be excused if that's not a problem.
Yeah, make them stay.
But, you know, he's going to amend your application as soon as you're out the door, and you're going to wish you had stayed, Peter.
I'm sure. Thank you very much.
Good night.
Holidays to everyone.
Is that
Yeah.
yours? Is that Peter's? Is that Peter's?
No, that's mine.
Okay.
Solemnly swear to tell the truth, the whole truth, nothing but the truth.
I do.
And state your full name, spell your last.
Alex Tweedy, Tweeedie.
And Alex, let me just ask you a quick couple questions. By whom are you employed?
Nave Newell.
And you're a registered civil engineer?
Yes, I am.
And you're licensed in the Commonwealth of Pennsylvania?
I am.
You've been previously qualified in this township as an expert in civil engineering, is that correct?
I have.
Actually, most recently, haven't you?
Very much so.
Okay. If I can just have him certify as an expert in civil engineering. I
Yes,
can ask
we've
him
heard
more.
you before. We
Yes.
we accept your
Okay.
qualifications.
Thank you. Alex, there's a question regarding the right-of-way. Can you just clarify that before we start?
There were some questions about I believe it's a use variance. We're asking to permit the use of a sign in the right-of-way.
No, I wouldn't classify it as a use variance.
Okay.
You're a civil engineer, you're not a lawyer, all right?
A variance for the sign to be located within the right-of-way.
Okay, and it's actually it's an existing sign, correct? And we're not moving it, it's just staying in the same place that it is.
Correct.
All right, and if you could just explain what is occurring with the right-of-way, so to speak.
Right. This portion of Radnor Chester Road is a state highway and has existing PennDOT right-of-way within that highway. We are offering additional right-of-way, but we're offering that additional right-of-way as township right-of-way. Even along a state highway, you can have two right-of-way portions. You can have a portion of the road owned by PennDOT for a certain width, and then additional width, you can offer that right-of-way to the township. So the specific question about granting relief for using a sign in Commonwealth right-of-way, we are not offering this to PennDOT. We are offering this to the township.
What's the purpose of offering the additional right-of-way?
For the township to be able to locate traffic signal control equipment and ADA ramp access along the road improvements, as well as complying with the minimum width that the township code seeks for right-of-way along this classification of roadway.
So you're saying that the sign right now is not in the right-of-way, but will be in the right-of-way after, assuming the relief is granted at some future point when you dedicate that?
Correct.
I don't think that we can address that now. It's not, the right-of-way is going to be created, and that should be done, by the township in terms of accepting.
If the township doesn't accept the right-of-way, then the relief is not required. Just like any zoning variance, if the project isn't performed, the variance expires and goes away. So
Yeah, I think they have I think they have two problems. First of all, the reason they have an impervious coverage issue is not because there's going to be a lot of additional paving, except when the new driveway comes in. It's because we compute that netting out the right-of-way area, and now we're going to have a bigger right-of-way area. The reason they need the sign relief, obviously, is because it's now going to be in a right-of-way where it isn't in a right-of-way. But physically, I think the only major change we're going to see is the new driveway and maintaining the old driveway as a right-in and right-out, right?
That is correct.
Yeah, so I think that's why they need the relief. I mean, we can give them the relief. That doesn't give them permission to do anything, but that will enable them to not cut their own throats by making the dedication. In other words, otherwise, if they give it away, they put their their property in violation.
I have no problem saying that if the board were to agree to grant that relief, saying that that action will not cause a problem under the zoning code. They still got to cut their deal with the township, and the township has to take its proprietary action to accept the right-of-way and to allow the sign there, and I don't want to get anywhere near that.
Agreed. I mean, the township and PennDOT, for that matter, have a lot of regulatory authority as well as potential property rights. Now, if you're not granting this to the Commonwealth, they won't have property rights, but they still have some regulatory authority because it abuts the highway. So I mean, everybody understands that we're not competent to, nor are we going to purport to deal with those issues. We're only going to say that which would have been a violation of this section will not be a violation by virtue of such and such.
And to be really precise, the fact that the township is supporting this does not mean that we can't stop the township from changing its mind as the project goes forward. We just can't get anywhere near that, in my view. Is that acceptable?
That's fine. Mm-hmm. Alex, you're the project engineer for this project, correct?
I am.
And Nave Newell prepared what's been marked as A3 that we have up here?
Correct.
Okay. And actually, A1 is the application, A2 is the deed, to the best of your knowledge. Are they true and correct?
Yes, they are.
Now, referring to A3 here, we're only talking about 240 Radnor Chester Road, correct?
Correct.
That's the only property that Mr. Gross, the applicant, or Mr. Gross's entity owns.
Correct.
Correct? So we're not talking about 252, which has been before this board before, or any other property. So we're just limiting this to the actual property that Mr. Gross owns, which is 240.
Right. This application is solely to the original ownership of 240.
Okay. Now, also, the current conditions. Could you just tell us where the current conditions are? And down here, if you want to start, there's Raider Road and...
Correct. As Nick showed, the outline for the property is generally a square with an out parcel that was previously known as, well, it's 252 Radnor Chester Road, which was previous applications but is no longer subject to this application. We currently have an existing access driveway that's about 100 feet east of Raider Road. Raider Road is located here, and Raider Road is subject to an application or a project by both the township and the school district for signal and turn lane improvements. The current use of the property has the entrance drive located to the east of that, unaligned with that driveway, as we previously discussed, and travels straight in through the property adjacent to the building and into the parking field and towards the parking garage that was previously built at the rear of the property.
Now, this application does not involve any additional building, correct?
Correct. There's no building proposed.
And there is no additional parking being proposed?
Nope. It maintains the existing parking yield that's existed on the property.
Mr. Tweedy, can I ask a question on that? There is a notation on the plan that we have in front of us, which is described as proposed parking expansion.
Yeah, it's to replace parking that's lost by the realignment.
Okay, so it's essentially...
We're moving parking around, but it's...
Spaces that are being relocated.
Yeah, it's a net zero change, but there's lost and gained parking.
What's the purpose of the realignment? And if you could show the board then how the driveway realignment will work.
Right. As we previously stated, the driveway is currently offset by Raider Road, and with the projects by the school district and the township to create a light and existing turn lanes into the property, PennDOT, the township, and the applicant all agree that a much safer configuration and good planning is to create a four-way intersection at that light, afford this user the ability to access Radnor Chester Road via the signalized intersection, and eliminate the potential conflict of turning movement conflicts and blocked driveway access at their existing offset intersection. So what we're proposing to do is put a curve in the driveway, extend it to the west, and put the main entrance directly across from existing Raider Road and give them access to the light that's being installed by the township.
And are there additional lanes being proposed on the whole intersection realignment?
Well, the school district is proposing left turn lanes that don't exist today, and there will be a dedicated left turn lane into the Radar Road, the high school access, and then as part of that project, with this driveway being realigned, we will be obtaining a left turn lane dedicated into our property as well.
And could you describe again the right-of-way, why the additional right-of-way is being proposed to be dedicated to the township? And if you could indicate where the various items would be located?
Correct. The existing PennDOT right-of-way as exists today is in this location here. The existing right-of-way for the road is 45 feet wide. Currently on the high school side, it's 25 feet wide, and then our half has an existing 20-foot right-of-way, which includes and covers the roadway itself, but not much additional area for any other improvements. As part of the signal improvements at that intersection, mast arm foundations and signal poles have to be mounted on the ground, which their alignment requires them to be in a location that's currently outside the existing right-of-way available. So the township has requested rights, or the township would need to request rights from 240 Radnor Chester Road to install those on the property. What we're offering is we would dedicate the additional right-of-way that the township subdivision code requests along that frontage, which would give them sufficient space to install any required handicap ramps for their sidewalks and the signal mast arm foundations and equipment as well.
So the additional right-of-way being proposed is no greater than what the subdivision and land development ordinance currently provides for.
Yeah, this classification of Radnor Chester Road in the subdivision code asks for a 80-foot total right-of-way, which would be a 40-foot half-width, which is, so we're offering, there's an existing 20-foot half-width which exists today, so we're giving the additional 20 feet to get to comply with the classification of the roadway in the subdivision code at a 40-foot half-width.
Referring to the sign, there is a indication on the plan, existing sign to remain. Can you just point to where that existing sign is?
At the existing entrance, directly west of the existing entrance is the existing sign for Mainline Health that currently exists today. It's currently behind the sidewalk, which is outside the PennDOT right-of-way, but when we dedicate the additional 20 feet, as we previously discussed, that'll put that sign within the township right-of-way.
I'm going to show you a couple photographs. First has been marked as A4, and if you could just indicate on the photograph, as you can see, where Radar Road is and where the existing entrance is.
Yeah. The photo is taken at our current driveway location, and in the driveway you can actually see the sign in question. And in the background of the sign offset, you can also see where Radar Road comes out and intersects with Radnor Chester Road.
And the sign, would there be any site distance issues with the sign on leaving it in that location?
No, it's set back far enough from the road for both driveway locations.
A5?
Is taken just past our existing driveway to show in the background the existing Radar Road location and also where the proposed driveway the current grass area where the driveway would be relocated towards.
A6?
This is standing on Radar Road looking at 240 Radnor Chester Road, showing the location of where the new driveway would be installed.
And A7?
Is on the 240 Radnor Chester Road property, looking along the ultimate location of the new driveway, showing the intersection with Radar Road.
Now, we talked, and it's been mentioned already, that part of the issue is by granting additional right-of-way, you're actually further increasing the impervious. What are the impervious coverage requirement? What is existing and currently what is proposed? And actually, we say impervious, but in the PB it refers to landscaped area, which is like just the opposite.
Right, yeah, it's actually that. So currently the property, a net property currently exists is 7.14 acres, which is to the existing PennDOT right-of-way that's there today. So currently, the impervious area subject to that is 66.91%, and then that would leave a landscape or a green area percentage of 33.09. And after we dedicate the additional 20 feet, that net lot area actually drops to 6.96 acres, which would increase the impervious coverage percentage. And actually, we rechecked the math, and there's a slight typo here, and it should be 68.47. percent in the post-development condition for impervious coverage, which would leave a green area of 31.53%.
Is there any manner in which the driveway could be relocated that would not increase impervious coverage?
No, there is not.
And is this the least amount of disturbance required to operate this site in the same manner as it operates today?
It is.
And you heard mentioned before about public health, safety, and welfare. Is there any negative to public health, safety, and welfare here?
No, the relocation of this driveway creates a more efficient and a safer intersection for the operation of the signal and the safety of vehicles exiting and entering this property from Radnor Chester Road.
Just when I was trying to find where the percentages were, which was the one that had the typo, and how do we, it's on A3, right?
A3, maximum impervious coverage in the proposed column. On the submitted plans, it says 68.47 or 41, and it should be 68.47.
And then underneath that should be likewise 31.53 instead of 31.59.
John, would you intend to, if relief is granted, would you intend to use this plan as an exhibit?
Yes, and I think we ought to annotate the correct exhibit.
Well, we could just have them correct it and get that to you. If you'd make,
How would we initial it?
Yeah, just,
Okay.
if you could initial the one that goes into the file, just write it in and initial it, that's fine. I've got my thing. It's the 68.41 becomes 68.47, and the 31.59 becomes 31.53, right?
Correct.
I have no problem with that.
That's all I have for Alex. The only other witness I would intend to present is Guy DiMartini from Traffic Planning Design, who has been working on this project.
are there any other questions for this witness?
I do have a question. The location on the plan which indicates that the existing driveway is to remain, to be used for deliveries and right turns in only. Deliveries can make left turns? And is that a function of the radius of the new inbound lane?
Correct. There's not sufficient turning movement with the radiuses that are required to make basically the S-turn movement to get into the driveway. The trucks that deliver to the property cannot make those movements, so we're keeping the existing driveway so that they have the functionality that they are afforded today for access.
So it's probably foreseeable that other motorists may see trucks making left turns into the property and say, that's for me.
Well, we don't believe so, because if you're making a left turn into the property, you're traveling eastbound and you would get to this intersection beforehand. Really, the only reason we're offering the right turns in for motorists and not making it a delivery-only driveway altogether is because if you're making a right turn into the property, you would get to the existing driveway first, and it would be better to bleed all those cars off the road and not put them through the traffic signal anyway.
Yeah, my concern is the left turns, not the right turns. I think it's a great solution. The left turns are the issue that I see, and if a left turn lane is backing up and there's another way of getting around that and getting in to the property through another left turn that the FedEx truck is taking,
Right.
Isn't that perhaps a problem?
I guess it could be potentially a problem if left turns did have to be prohibited there at some time due to that problem. Operationally, he could force his vehicles to come up King of Prussia Road, turn left on Radnor Chester, and require all delivery traffic to turn right into the property. There is an option to that. We don't foresee that it's going to be a problem, but if operationally it had to change that way, he could make that condition.
I mean, because there are ways of physically dealing with this entrance that would which would make left turns harder. They'd have to go overland, perhaps, or some sort of mechanism or arrangement whereby
and we've looked
the right turn is the obvious way to go.
We've looked at options for pork chop islands and such different channelization. The difficulty is the reason this driveway is needed because of the large trucks coming in, even their turning movements through this driveway, if we put some kind of porch up island in with a mountable curb, that truck would be driving over it every time it made a delivery.
Now, this turning has to be approved by the township and by PennDOT. I mean, there's going to, I guess it's not land development, but the whole, because, this is access onto a state road. PennDOT's got to approve what you're proposing.
Yes, and as Nick
That
said.
driveway already has an occupancy permit, right? You were talking
Well,
about the existing driveway.
the reload.
Yeah, that already has one.
Yeah, the relocation, and guys from TPD is here to speak to that if we need to. There is an application in with the township, and Amy's aware of it as well, for the signal and the turn lane improvements, which show this driveway relocation, and it's currently under review with PennDOT. And then a grading permit would be required with the township just for the earth
But again, these
disturbance.
really aren't the issues before us. Our only issue is
It was zoning issues.
the two technical violations that'll be created by this. Are we going to give them a pass so they're not technical violations? That's really the only issue.
Correct, everything else is a
Yeah, the rest of it's somebody else's issue.
Health, safety, welfare, another left turn lane, that's,
Yeah, but whether they have the sign
We're
there or
not
not.
deciding on that tonight.
Or whether they
It's
have
just
the
a
new
sign.
driveway or not, this driveway's still there. It's,
no, but I mean, it's a variance, right?
No, not for the
No,
driveway.
it's just for the
existing
sign.
driveway.
Right, for the sign, yeah.
For the sign, yes.
But implicit in our approving that, don't we need to have some comfort that the end, I'm sorry, isn't implicit in our approving that, which frankly I have no issue with, don't we need to have comfort with the idea that the entire development plan, it's not a development plan, excuse me, the entire proposal isn't going to make things worse?
I believe PennDOT has to approve it anyway, so that's,
I'm sure they do,
I think,
but I think we do too, and I think we have
and the
standards.
township has to take accept the dedication. None of this
Right.
happens unless they're satisfied.
Yeah, I understand, yeah.
Hi.
Good issue, wrong body, wrong time, I think.
Promise to tell the truth, the whole truth, and nothing but the truth.
Yes, I did.
And your full name for the record, please.
Amy Kaminsky. Hi, I'm the Township Traffic Engineer. I work for Gilmore & Associates, and I just wanted to weigh in on the discussion that you're having about the whole PennDOT. It's likely that PennDOT is going to require them to do truck turning templates at that intersection or at that access. And if they decide that they need to widen it or make some improvements to that access, that's something that would have to happen. So be assured that it would be looked at. But my understanding is that this is not going to go through land development. I believe that it's going to be handled under a grading permit. But PennDOT will be weighing in on it, and there's been some discussions about it between the township, the school district, and Mr. Gross.
The PennDOT still retains the right to say no, right?
They do.
I mean, we've not crossed that bridge.
They actually support this and have been, have
they're-
wanted him to move the driveway.
Yeah, but I mean, in terms of the detail that Mr. Riley is talking about, PennDOT has to finally sign off on that.
Yes, even though that they do have access to that road, it may predate the design requirements that are currently required for access to state roads. So when you come in and make improvements on your site, it opens up all your accesses, and PennDOT may opine on it and make them do some improvements that they perhaps weren't aware of, but
And they can say no if they don't do the improvements.
That's right.
Or they can say no, period.
that is true. So, they haven't obtained the HOP yet, highway occupancy permit, but during that process, that's when those things will be discussed and determined.
I think it's just another reason, John, to make sure that, we only apply, really, or do address the zoning code, and we absolutely carve out, and I will carve that bush out way around the roots, that there's any estoppel or commitment by either the township or PennDOT or any impairment of their authority to approve or anything like that.
Okay?
Thank you.
I'll quickly call Guy DiMartino, who's actually been for TPD, who's been the traffic designer for both the school district and for Mr. Gross on this project.
Promise to tell the truth, the whole truth, nothing but the truth.
I do.
And state your claim.
Yes.
Spell it, please.
Guido DiMartino, DiMartino.
And Guido G.
Guido.
Guy, I thought I had an Italian name. By whom are you employed?
Traffic planning and design.
And what is your profession?
I'm a civil engineer,
Okay.
registered professional engineer.
And you've been certified as an expert in traffic planning and design previously in other bodies, and probably here in Radnor also, I believe.
Yes, I've certainly been before the board and planning commission. I'm not sure if I've ever been before the zoning hearing board, but
Okay.
I've been in this township before.
All right, and you've been certified as an expert.
I have.
I would just ask that his qualifications be held as an expert in traffic design and planning.
Sure.
Okay, here we go. Guy, can you explain?
As long as you don't disagree with our expert.
Can you explain your involvement in this project?
Certainly. TPD has been retained by Mr. Gross, and we've also been involved working for the school district to prepare the design that was discussed earlier this evening for the roadway improvements that are planned along Radnor-Chester Road. And we've been working hand in hand with Ms. Kaminsky, Gilmore Associates, as they're planning. They're doing the signalization of that, of this intersection in question. So our design, our roadway design has worked hand in hand with their office so that we're having one cohesive improvement scheme.
And you heard the testimony here this evening from both Alex and Amy. Is there really anything you need to add or to that, or could you just describe why don't you describe the progress of this intersection is currently?
Sure. First I'm going to start by, as Ms. Kaminsky had mentioned, there's numerous meetings with PennDOT where all parties were involved. Mr. Gross, the school district, the township, and PennDOT to discuss this intersection in question. And through that, PennDOT has indicated that they are in favor of this realignment. It would enhance the safety of the area. So PennDOT is in support of a one four-way signalized intersection. As far as the design of the roadway goes, on behalf of the school district, like I said, we are designing the roadway improvements. We did submit a HOP application in, I believe it was in October. It was October 20th. We submitted our first submission to PennDOT. We received comments back from the department in late November, and we are working on the resubmission currently. There's some loose ends we're tying up, but we will be submitting to the department in the next few weeks. And then the ultimate goal in terms of the roadway improvements is that they would go out to bid sometime in the spring and then be constructed this summer prior to the start of the school year in September.
I have no further questions.
Any questions from the board? No questions from the witness.
Just request that the exhibits be made part of the record, and I would rest.
Anyone else here to speak? There's only two people here, and Mr. Gross has three that haven't spoken yet, so I guess you're not here for this.
I thought I'd heard counsel for Brandywine said he had something to put up in the
I have
record.
a brief remark to make, and I don't know if Amy has anything she wants to say first.
Yeah, I just wanted to, Mr. Tweedy, could I just ask you just real quick questions just to clarify? And I may have misunderstood what was being discussed, but we were talking
Mr. Tweedy,
about...
please grab a mic so we can hear your response. And our loyal television audience can also hear it.
During your testimony, there was some discussion about the right-of-way, and I may have misunderstood, but it sounded like you had indicated that the township would be making some ADA improvements within the right-of-way near the existing driveway.
Well, no, the applicant is doing some of the ADA improvements, and the township is doing the signal plan. The ADA improvements are required as part of the signal plan, and there's improvements being done by different parties, but they'll all be located within the right-of-way that's ultimately granted.
Okay, so I know from my own personal experience that the driveway, the existing driveway, does not have the correct crossings for ADA, to meet ADA standards. So I just wanted to make sure that the record was clear who would be making the improvements on the existing driveway.
Right, yeah, the applicant is relocating the driveway and then constructing ramps at either side for the required crossing along that driveway.
Okay, but how about at the existing driveway? Because once you come in and touch the site, you're required to make those improvements.
Yeah, I mean, that's subject to PennDOT review. It's
Amy, this is a good issue, but it has nothing to do with why
Okay,
they're here.
I just wanted, because the comment that he made that the township would be making this improvement was on the record, and I was concerned.
Well, that doesn't make it so. That's just what he
Okay.
said.
Okay.
Has no legal effect.
Okay, I didn't know, I just was hoping
Yeah.
to get some information on there that was clarified.
Yeah, again, we are, all
Okay.
we're concerned about is the zoning code. We are not in any way limiting the township or, restricting its authority. As far as this, any approval would go, the township could wake up tomorrow morning and say, we don't like it anymore, and they're free to do that.
Okay, then I have no other questions.
Just conscious of the fact that that new clock, the alarm may go off any minute, and the hour is late.
Excuse me, Alex.
Welcome back, George Brosman.
Thank you. I'll just be very brief. My clients, as you may recall, had opposed the prior application for this property that would have had an addition that was proposing additional traffic to the roadway network in the area, which has problems, as you may know. And there was a parking structure proposed with a zero setback or an expansion to one. So this application is nothing like that application. So my clients are not opposed to this application to the extent that it's providing the impervious coverage relief and sign relief needed to align the driveway, as has been testified to, and basically to facilitate the construction of the signal at Rader Road and Radnor Chester Road. You may not be aware of it, but Brandywine Realty Trust has already provided direct support for this traffic signal through a very substantial contribution that it had made toward that effort.
No commercials allowed, George.
In connection
You're
with
on the record.
200, the development it did at 200 Radnor Chester Road in accordance with the land development agreement with the township. My clients do believe that while this signal will provide some marginal benefit at the intersection where it will be installed, it's not going to be a magic bullet to cure the traffic issues that exist in this area, and it won't address the additional traffic that would be projected for the roadway as a result of a lot of the expansions that we've heard about in the area.
I'm going to object a little bit here. We're getting...
I'm done.
Yeah, hi.
But we're not opposed to this particular project, and we hope that it will be restricted, as Mr.
George, we
Ryan
get
always
your
does,
point.
to the plan that was presented.
And without meaning to insult you, we're not as interested in this point as we have been in other things you've had to say tonight.
Sure, I'm
Okay,
done.
you know.
Thank you.
I think the chair is speaking for himself when he makes that comment.
Thank you.
Okay, well, since there's no one else that wants to speak on the issue, the chair will entertain a motion, hopefully one very narrowly worded motion.
I'll try. Make a motion to grant the applicant a variance from section 280-60B relating to minimum landscape coverage requirement and section 280-122C5AC relating to signage in a right-of-way only to the extent and consistent with the plan presented as Exhibit A3.
Do we have a second?
Second.
Any discussion? Yeah, I think I'd like to word that as narrowly as possible, that it's the minimum relief necessary so that they are not in violation, deemed in violation of either of those sections by virtue of doing those specific things as shown on that plan. As long as we can be that narrow, that's really all that they need, and that's all we should give them. So,
Mr. Chairman, I want you to know that one of my dreams is to make a motion and have you say Bill had it exactly right.
dream on, Bill. It's important to have dreams. Anybody accept that amendment or that instruction to our solicitor that it's drafted that way? You accept
No
that?
objection.
No objection. Okay, all in favor of the motion as so amended, say aye.
Aye.
Any opposed? Motion carried.